A federal appeals court just handed California gun owners one of the biggest Second Amendment victories in 60 years. The same Ninth Circuit that gun owners have been losing in for decades just ruled that California's near-total ban on open carry violates the Second Amendment. But here's what nobody is telling you, and this is the part that could put you in handcuffs. The ruling is currently frozen, stayed, not in effect. And if you walk outside with a holstered pistol today in Los Angeles, San Diego, or San Francisco, police can absolutely arrest you. The DA can absolutely charge you. A jury can absolutely convict you. The law is unconstitutional, and it's still being enforced. 10 years in the firearms and constitutional law industry. And Baird versus Bonta is one of the most significant open carry decisions in American history, with a legal trap buried inside it that the gun community on social media is completely getting wrong. By the end of this video, you will know exactly what the ruling does, exactly what it does not do, and exactly what you need to watch over the next several months. Gun Guide Pro is a brand new channel building something genuinely important here. Real legal analysis, zero misinformation. Every subscriber gives us the motivation to keep delivering this level of coverage for you. Hit that subscribe button right now. Before we go further, if you carry legally or care about open carry rights, hit that subscribe button right now and turn on every single notification. We are a new channel, and every subscriber helps us reach more gun owners who need accurate legal information. The Ninth Circuit's en banc decision could come within months. The Supreme Court may weigh in by next term. When anything drops, you need to know within minutes, not weeks, from someone at the range. Drop your state in the comments immediately. Are you in California or another Ninth Circuit state watching this develop? I personally respond to every single comment. Let me give you the full picture of what just happened, because understanding the history makes the ruling's significance undeniable. California's open carry ban goes back to 1967, nearly 60 years ago. Back then, the Black Panthers were openly carrying rifles for self-defense in Oakland. Governor Ronald Reagan signed the Mulford Act to shut it down. That law grew into what California has today. Penal Code sections 25,850 and 26,350 together making open carry a crime in any county with more than 200,000 people. That covers approximately 95% of where Californians actually live. Los Angeles, San Diego, San Francisco, Sacramento, Orange County, all of it. For 60 years, open carry was effectively dead for the vast majority of California residents. Then, Mark Baird, a law-abiding citizen from Siskiyou County near the Oregon border, filed suit arguing the ban violated his Second Amendment rights. The district court dismissed his case. He appealed. And on January 2nd, 2026, a 3-judge panel of the Ninth Circuit ruled 2-1 in his favor. The court that gun owners had written off completely just said open carry is constitutionally protected and California's ban is unconstitutional. Comment right now. What state are you watching from? And which politician in your state do you think has done the most damage to open carry rights? Name them directly. I want to see who this community holds accountable. Let me walk you through exactly what the 3-judge panel ruled, because the legal reasoning here is as significant as the outcome. The majority applied the Bruen framework. The Supreme Court's 2022 decision requires that any gun law must be consistent with America's historical tradition of firearm regulation going back to 1791. The government must find real historical analogs, not just similar-sounding laws, to justify modern restrictions. The panel's conclusion was direct. Openly carrying a handgun in public is squarely protected by the plain text of the Second Amendment. The historical record makes it unmistakably clear that open carry is part of American tradition. California tried to point to old surety laws and a handful of 19th century statutes. The court rejected every single one. Different conduct, different justifications, different context. Not historical analogs, historical noise. And here's the part that should genuinely alarm every anti-gun politician in California. The court called out California for leaning on racist and xenophobic laws from the post-Civil War South. The court said, that kind of history is the history the Constitution left behind. We are not using it to justify modern bans. That single holding poisons a well that anti-gun states have been drawing from for years. Courts can no longer say, well, Reconstruction-era Southern states banned certain people from carrying, so we can ban everybody. That argument is dead. Tell me in comments, what is your favorite Second Amendment ruling of your lifetime? Heller, McDonald, Bruen, or this Ninth Circuit decision? Drop your pick and why, because I want to understand what this community sees as the most important legal victory. Here's the part of this ruling that legal scholars are calling a genuine earthquake eye, and it goes far beyond open carry. California made an argument that sounded reasonable on the surface. They said, we allow concealed carry permits so we can ban open carry. If you want to carry in public, you have that option through the concealed carry system. The Ninth Circuit rejected that argument completely. The ruling states directly, concealed and open carry are not interchangeable under our nation's historical tradition. A state cannot ban one mode of carry simply because it allows another. Think about what that means. Every state in the Ninth Circuit's jurisdiction, California, Oregon, Washington, Hawaii, Nevada, Arizona, Idaho, Montana, Alaska, that has been using the you have concealed carry so you don't need open carry argument, just had that logic completely demolished. And there's one more element buried in this ruling that reveals just how deliberately California constructed this system. Judge Kenneth Lee wrote a separate concurrence calling out California for what he literally described as subterfuge. He pointed out that California admitted in court they have zero record of ever issuing even one open carry license. Not one. The application they require you to file is a 17-page concealed carry application that doesn't even mention open carry anywhere. A federal judge called out California for creating a license system that exists on paper but was deliberately designed to never actually function. Judge Lee said, constitutional rights should not hinge on a Where's Waldo quiz. Drop your prediction in comments. Do you think California deliberately designed their open carry license system to never actually issue licenses? Type deliberate subterfuge or just bureaucratic incompetence, because the answer to that question determines whether California violated gun owners' rights intentionally. Here is the part that the gun community on social media is getting completely wrong, and getting it wrong could put you in prison. The ruling is currently stayed. That means it is frozen, not in effect. The mandate has not issued. In plain English, even though 3 federal judges declared California's open carry ban unconstitutional, penal codes 25,850 and 26,350 are still on the books, still being enforced, and you can still be arrested, charged, and convicted for open carrying in California today. California's Attorney General immediately filed a petition for en banc rehearing. That means California wants all 29 active Ninth Circuit judges to rehear the case as a full court, not just the 3-judge panel. If the full court grants that petition, the panel ruling gets wiped away and they start from scratch. And here's the honest risk assessment. The Ninth Circuit has historically been hostile to gun rights. If they grant en banc and reverse, we lose this ruling entirely. If they deny en banc, California almost certainly takes it to the Supreme Court. Do not let anyone on social media convince you that open carry is legal in California right now. It is absolutely not. The person telling you the law changed is the person who hasn't read past the headline. Wait for the official mandate, wait for enforcement guidance. The gun owner who carries based on an expected ruling is the gun owner who gets arrested while that ruling is still in appeal. Comment your answer. Did you know the Ninth Circuit's open carry ruling is currently stayed and not in effect? Type knew it was stayed or thought it was already law. because misinformation in the gun community on this case is genuinely dangerous, and I want to see how widespread it is. Here's where this case becomes the most important Second Amendment battle currently heading toward the Supreme Court. The Baird ruling created a direct circuit split with the Second Circuit's decision in Frey versus City of New York, where the Second Circuit went the opposite direction and said New York could ban open carry as long as concealed carry was available. Two federal circuit courts, two completely opposite answers to the same constitutional question. Can a state ban open carry as long as concealed carry is permitted? Ninth Circuit says no. Second Circuit says yes. That kind of circuit split on a constitutional question is exactly the situation the Supreme Court exists to resolve. The justices have made clear since Bruen that they are not satisfied with how lower courts are handling Second Amendment cases. A circuit split this direct, and on a question this fundamental is exactly what gets granted certiorari. And here's the strategic element that should concern California deeply. If California loses en banc and takes this to the Supreme Court, they are asking a court with Thomas, Alito, Gorsuch, Kavanaugh, and Barrett to reverse a pro-gun ruling. They are walking into a constitutional ambush. A Supreme Court ruling affirming the Ninth Circuit's logic would create nationwide precedent. States could not ban open carry simply because concealed carry exists, and the racist historical analogs that anti-gun states have relied on for years are completely off the table. Tell me in comments, do you think the Supreme Court takes this case? And if they do you think we get a nationwide ruling protecting open carry rights or a narrow decision that only applies to specific circumstances? Drop your Supreme Court prediction. I want serious analysis. Here's why this ruling matters for gun owners in Washington, Oregon, Nevada, Arizona, Idaho, Montana, Alaska, and Hawaii, not just California. The Ninth Circuit's jurisdiction covers 9 states and over 65 million Americans. The legal reasoning in Baird versus Bonta applies across all of them. Every gun law in those states that uses the "you have one mode of carry so we can ban the other" argument is now constitutionally vulnerable. And here's what makes the Baird ruling even more powerful than most people realize. The rejection of racist historical analogs sets precedent that travels far beyond open carry. Anti-gun states have been leaning on post-Civil War Southern laws to justify modern restrictions for years. Courts operating under the Ninth Circuit's jurisdiction can no longer use that history. Every restrictive gun law in every Ninth Circuit state that was justified by pointing to laws designed to disarm Black Americans and other minorities just lost its historical foundation. That's not a small legal development. That's the removal of an entire category of historical evidence that anti-gun states have been relying on in Second Amendment cases for the past several years. Comment your answer. Are you in a Ninth Circuit state other than California? And do you think this ruling will affect how gun laws in your state are challenged over the next 12 months? Type your state and "laws in my state are now vulnerable," or "my state doesn't have these restrictions." I want to build a complete picture of the impact. Here is your complete action plan and timeline, because staying informed on this case is how you protect your rights during one of the fastest-moving legal periods in Second Amendment history. Watch for number 1, the en banc decision. The Ninth Circuit will decide whether to rehear this case with all 29 active judges. If they deny en banc, the 3-judge ruling stands and we move toward enforcement. If they grant en banc, we start over. Timeline: months. Watch for number 2, the Supreme Court. The circuit split with the Second Circuit makes this exactly the kind of case SCOTUS takes. If California loses again and petitions, oral arguments could happen by next term. Decision by 2027 could create nationwide precedent on open carry. Watch for number 3, California legislature. The court was clear. It's not the judiciary's job to rewrite California's gun laws. If the ruling takes effect, Sacramento must either create a real urban open carry licensing system or leave open carry effectively unregulated. Expect emergency legislation. And here's the bottom line. Every gun owner watching this needs to understand clearly. Even if the ruling eventually takes full effect, federal gun-free zones still apply. Schools, federal buildings, post offices, sensitive places rules still apply. Private property owners can still prohibit firearms. Brandishing laws still apply. What changes? The simple act of having a holstered handgun visible on your hip while walking a public sidewalk would no longer be a crime by itself. For 60 years, that was a guaranteed arrest. Soon, it might not be, but we are not there yet. Here's what you do right now. First, subscribe to Gun Guide Pro and hit that notification bell immediately. We are a brand new channel, and every subscriber gives us the motivation and resources to keep covering these developments. The en banc decision could come with no warning. When it drops, I cover it within minutes. Second, smash that like button and share this with every gun owner you know in California or any other Ninth Circuit state. Most people think open carry is already legal in California right now. Your share corrects that dangerous misinformation. Third, answer every question I asked. What state are you in? Which politician damaged your gun rights most? What's your Supreme Court prediction? Did you know the ruling was stayed? Drop everything in comments. I personally read and respond to every single one on this new channel. Fourth, any questions about Baird versus Bonta? What happens if en banc is granted? How this affects open carry laws in your state? What to do when the mandate eventually issues? Ask me anything below. 10 years in this industry. I track every major Second Amendment case from filing to final ruling. The Ninth Circuit just ruled that 60 years of California's open carry ban is unconstitutional. The fight to make that ruling permanent is just beginning. Stay informed, stay patient, stay legal. I'm Michael from Gun Guide Pro. See you in the next one when the en banc decision drops.